Hi, everybody. Thanks for spending lunch with me, I guess is what I should be saying to you, particularly since we're going to be talking about HIPAA and how you're going to access records. So the first slide that we have is basically the disclaimer that you see these all the time when we do CLEs, and really what it says is that the stuff we're going to talk about is complicated. I would be hard-pressed to explain anything more complicated than HIPAA and data security law, and so that's what we're going to talk about today. This is me. I'm a senior shareholder at Davis Brown. I do employment, labor relations, health law, litigation, and data privacy and security. I am also my firm's privacy officer. So I do a lot of the work on our internal data privacy and security, how you manage it. It also means that I spend a lot of my time answering questions for other attorneys across the state, but how you access certain records, how you get things, what would happen, why somebody's not cooperating in producing documents. I am always happy if I can, and it's not one of my clients, to answer a question. So my email address is on here. If you have a question today, do make sure you type it in, and Christy will try to let me know, and we'll answer those as we go along. But if you have a question that doesn't get answered, feel free to shoot me an email. I'm really always happy to give that a try. So what we're going to talk about today is HIPAA, and we're going to talk about HIPAA and how that interacts with how you're going to attempt to get records, typically going to be medical records, but it could be billing records, it could be other types of things involved in a wide array of cases, everything from medical malpractice to custody cases to how you get your damages in a car crash. So we're going to talk some about that. I do think that it's important to understand some of the key terms of HIPAA, and so let's talk about that first. The first is covered entity. And the reason you need to know about covered entity is because HIPAA only applies to a limited number of people or a limited grouping. It is providers, so that's going to primarily be hospitals, doctor's offices, dental offices, those kinds of things, an actual provider of a healthcare service. It also applies to labs, and so the secondary services that might be provided, sleep centers, MRI centers, radiology, all the kind of lab work, lab testing, HIPAA is going to apply to that. They're going to be covered entities. And then insurance to the extent that it is health insurance. So if you have a health insurance provider, they're going to be a covered entity. Also, if you have a secondary company like Task, which manages flexible spending accounts, because those have a medical component, a lot of times they will be covered entities. The reason that it's important to know who a covered entity is because HIPAA only applies to covered entities and their business associates. And one of the things that happens a lot is attorneys will call me up and say, well, they won't produce this because of HIPAA when it's not actually HIPAA. All right, so if you're attempting to get workers' compensation information, if you're involved in an employment lawsuit and you want the drug testing results from the employer, none of that is HIPAA. Family and Medical Leave Act isn't HIPAA. None of those kinds of things are in fact HIPAA. It's really only this covered entity sort of issue. The other people that you might be getting records from or you might be looking to are business associates. Business associates are those people who provide services to a covered entity. So you provide a service where you're going to access patient data or patient information. Covered entities are a really broad array of people, broad array of providers, which means business associates are also a broad array of providers. So if any of you that we're talking with today, if you are developing or already have practices where you do work for dental clinics or anybody that might get payment for Medicare, Medicaid, mental health, in-home care, those kinds of things, you're going to be a business associate with that covered entity, which means all the requirements, all the rules, the privacy and security components of HIPAA are all going to apply to you. And so you need to be thinking about, you know, if I have this practice, am I meeting the requirements of HIPAA? Am I doing the addressable security requirements? Do I have the right policies in place? Do I have a notice of privacy practices? All of those things apply when you as an attorney are a business associate. You're also required to have both a privacy and security officer if you're a business associate. As I said in the beginning, I'm the privacy officer for my law firm. Our tech guy, our head tech guy for IT is the security officer, and we had a committee called Confidentiality and Security. So that's the kinds of things that you need to be thinking about if you are in fact a business associate with any group. Now, if you are doing, let's say, car accidents, right, and you're getting medical records for damages purposes, you're getting records that relate to your person, you have a wrongful death, something of that type, those records aren't going to be HIPAA. When they're held or owned by the covered entity, they are HIPAA protected, but once they pass into your keeping, that is no longer a HIPAA issue. You're not a business associate because you obtain those records. You are a business associate when you do work on the behalf of a covered entity. And so that's a distinction that we need to make there. If you are a business associate, you are required by law to have a business associate agreement. That sets forth obligations of the business associate under HIPAA. For our purposes, you may have an instance where you want records from the business associate itself. So let's say that there's some sort of review of billing statements, or maybe there is an internal review relating to certain kinds of care, those types of things, and that went out to a business associate. The business associate agreement itself will govern how they provide that documentation to you, whether or not a subpoena is sufficient, whether or not they have to give notice to the other party, to the covered entity, if they have to object. So there may be some language in business associate agreements that impact on how you receive information or data from the business associate, him or herself. If you are a patient, those issues are different. Patients are entitled to access data, they're entitled to an accounting of data, and so it is different when a patient is requesting that patient's medical records than when you are requesting other kinds of data or data for other people. So there are different rules that apply to that. Another term that you will hear very frequently is PHI or PII. That's personal health information or personally identifiable information. That means basically every piece of data that identifies a patient. That is everything from social security numbers and maiden names and insurance numbers all the way up through the actual medical record. So that's all going to be PHI. All of that will be protected by HIPAA. So you can't just say, well, just give me the list. Yeah, that's not how that works, because that is all HIPAA protected information, including billing data, those kinds of things. The other term that you might sometimes hear is de-identify, which in HIPAA is a pretty broad term. You're normally only going to get de-identified information if you are working with a research group and you are doing research, so get a lot of de-identified information for comparative research purposes. You might get de-identified information if you're involved in a lawsuit and you've asked for comparators. So they might choose to provide that information subject to a protective order, but by de-identifying the patient. So you get patient A, patient B. It can be extremely difficult for a hospital to strip out the identifiers. There are so many identifiers in individual records that it is a very time-consuming, very costly process. In addition to that, if we are talking about a small facility, a small provider, something that is rural, other things, okay, as opposed to addresses and social security numbers, can also be identifiers. Sometimes the treatment or the disease itself can even be an identifier, like Huntington's. So if you have one family in the community that experiences Huntington's, that might be something that has to be stripped out if, in fact, those records are going to be provided. So de-identification under HIPAA is really a very broad thing. And if you are looking for those kinds of comparators, you're going to need to work with hospital counsel or the provider's counsel to try to figure out how you're going to do that in a way that is both HIPAA compliant and gets you what you need. So that's really going to require some discovery discussion. Notice of privacy practices is another term of art. That is basically the rules. That's what you have. This is what you as an entity tell the world, this is how I'm going to use the information. If you are a business associate with a provider, a hospital, an insurance company, something of that type, you have you have to know what the notice of privacy practices are for the covered entity. You have to understand those because you can't produce things differently than they would do it under the notice of privacy practices. As a subcontractor, as a business associate, you're going to be held to those standards. The final term of art is treatment, payment, and operations, or TPO. Treatment, payment, and operations are intrinsic functions which do not require authorization or consent. So treatment, I don't need a patient's consent to give the cardiologist EKG results that came in through the ER. I don't need a patient's consent, typically, if they break their arm and I need to send them to another orthopod and I'm going to refer them out. That's all treatment information. Now that does still come under what's called the minimum necessary standard, which means if I'm treating your broken arm, I don't get to go look at your STI testing to see if you had chlamydia 10 years ago. You really have to focus on what is the minimum necessary needed to treat the position. Payment is the insurance issue. So for the purposes of providing payment, for contacting the insurance company, for studies done by CMS, Center for Medicare and Medicaid Services, that kind of thing, they're not going to need a special consent for that. They're going to be able to access a wide array of things under this TP&O exception. The final one is operations. So I don't need a patient consent to do an internal review of infection control. I don't need patient consent for peer review, which is the process by which we send out documentation to determine how a case was handled. I don't need patient consent for internal operational purposes. The place this starts to get sticky is when you practice employment law and you're dealing with various license holders. This morning I had a call from an attorney in Buffalo, and he wanted to know if they could use the data that was received by their clinic about one of their drivers. They have a valet driver, and he has a significant opiate problem. They've looked, this is in New York, and he has a significant problem, and they want to know if they can take that treatment information and apply it to his job and then just simply terminate him because they now know about the opiate issue. The problem you have with that is that the data was learned as part of the treatment process, which means it's HIPAA protected. Typically, when you just have somebody who is a valet or a cleaning person or something of that type, unless it forms a true positive risk to your patient population, you're probably not going to be able to use that data. The place it gets trickier, particularly in employment law, is when you have a license holder. Because if let's say a nurse treats a nurse who comes into the ER with an illegal drug overdose, that nurse is going to have a separate ethical obligation to report to the Iowa Board of Nursing. So you're going to have a license holder, so that'll create a layer of reporting which will trump HIPAA. So you're going to have this layer of reporting, and then that's going to come back and typically is going to result in the termination of the employee or possibly a suspension, something of that type. But there are HIPAA issues that would normally be HIPAA, but when you have a license holder or somebody who works for the facility themselves, it will no longer be the same HIPAA issue. There is a California case involving a physician who was treated for narcotics and a series of other substance abuse issues, and what OCR, the Office of Civil Rights, who typically enforces HIPAA, said was that that fell under the operations exemption. It's not a reported case. OCR refers to it a fair bit, but you can't get access to the underlying reasoning, so that's a little hard to manage. But those are the key terms. The real reason to kind of understand that functionality and how HIPAA works is because we misuse it. All right, we misuse HIPAA all the time. HIPAA has become the shorthand for, I don't want to give that to you. Okay, oh, well, that's HIPAA protected. Well, lots and lots of things are not HIPAA protected. I had somebody from the legislature call me and ask me if water quality results were HIPAA protected. No. Okay, they don't relate to patient care. They're not done by a covered entity, which means they're not HIPAA protected. So we're looking for a big umbrella term, but this is actually a much more surgical approach. It's much more specific and doesn't cover everything. So it's a series of regulations. It creates a privacy and security framework, and those are two different things. The privacy and security for all the personally identifiable information, which is created by a covered entity or held by a BA. I've given you the site if you ever want to look at the bulk of the bulk of HIPAA is really the regulations. If you look at the statute, it doesn't tell you anything. It's really the regulations and then the high-tech rules. So that's found in 45 CFR 160 and 164. The core of HIPAA is about patient notice, okay, that the patient needs to know and understand how his or her records are going to be used. That is also true of 622.10, which is the Iowa statute which relates to some of this production, 228 and 229, which are Iowa statutes relating to mental health, those kinds of things. The core of all of these rules and the intent to protect people is really about notice. It's about patient understanding and notice. And so if you are thinking about trying to obtain information, you need to be thinking first and foremost about notice. Has the patient had notice? Does the patient understand what is being requested? Does the opposing counsel understand what is being requested? Because all of those things are what a hospital is going to be looking at, or a clinic or other kind of provider. A CE is going to be looking at, does everybody know, and does anybody object? And that is a place that we have some real issues. So HIPAA was first created in 1996. Don't go back to the 1996 rules. Okay, that's not what you want to be looking at. What you want to look at is the high-tech rules, which are January 2013. High-tech changed a lot of the original rules, so if you have a question or a problem and you go back to those first rules, it's not going to give you the right answer. So anytime you have a question or issue, start with the 2013 rules. They're called the Omnibus Regs and High-Tech. They cover the bulk of what you're going to look at. There's also, they're in 4 parts. The largest part is, well, one of the parts is on GINA, the Genetic Information and Non-Discrimination Act. By and large, that doesn't impact on providers, but if you have other cases that involve GINA, like insurance or maybe a FERPA case, then you're going to want to look at the GINA sections. HIPAA breaks down into 2 big pieces, okay? Privacy rules, which is all about employee training. It's about policies. It's about enforcement. When you have a problem with HIPAA, when someone says, I can't produce that because of HIPAA, they are talking about privacy rules. All right? They are talking about the rules that say that PHI is protected, that we have this overarching requirement to protect this information from anybody who wants to look at it. So that's what they're talking about, and that's what you want. If you're having trouble getting information and you go to the same person a lot, you might ask for their privacy rule documentation, or you might ask for their privacy rule policies. You can typically go online for almost any provider and access their notice of privacy practices, which will give you some insight into how they produce it. Now, by and large, you're just going to talk to HIMSS, the Health Information Management Group, or the HIMSS manager or director. But if you really have a lot of stuff, it's a big corporation, are having trouble managing it, those are places you can go to get additional information on how you might request things. The second piece of HIPAA is the security rules. Usually, unless you have a data privacy and security case or you have some kind of misappropriation under the Iowa Identity Theft Act, you are not normally going to be dealing with the security rules. The security rules break down into two main parts, the administrative rules and the technical rules. The administrative rules look to the issue of how do we manage the technology? How often do we check the firewalls? Who watches the watcher? Who checks to make sure IT is doing what they're supposed to be doing? Those kinds of things. The technical rules are things like encryption, how you access data, whether or not you have to have multi-factor authentication. Those are more of the technical rules and the things that we see. There are a lot of technical rules that relate to certifications, relate to how you manage these things, relate to how you get from point A to point B, but most of those rules really are the province of IT. Okay, so again, unless you're going to have some sort of issue that relates to data security, you've got a data security case, the technical rules aren't going to be the biggest part you're going to need. Those two main sections also drop down to two subcategories. One is required and one is addressable, which means there are certain things that are required by law, and there are other technical things which are addressable, which means you might have them or you might not. So you can get wide divergence from a two-person surgical center to a large hospital in terms of what kind of technology they have in place, how they access, how they use their portals, all of those kinds of things. One of the things to remember when you are interested in documentation, particularly if that documentation is, let's say, EMS personnel, emergency services personnel, you've got OWI, you had somebody picked up or hurt, that kind of thing, is there are a lot of ports of information that come under the security and privacy rules but aren't always well discussed. One of those is texting. There's a fair bit of texting that occurs in the healthcare setting as people are trying to check medication levels, to check to see if something's ready, that kind of thing. Very little of that is going to be what we call SMS or secure messaging services. Typically, though, if you're going to have if you have a case that involves medications, right? So you've got prescription orders, medications, those are all going to have to go through a secure messaging system. So you might have the EMR, the electronic medical record, you might have SMS, which is the secure messaging system, and you might have secondary texting. So when you're thinking about records and the kinds of records you might need from, let's say, a crash site, you want to think about all those records as a whole, not just the EMR. Typically, the EMR is also going to have an audit trail, a log, and metadata. Normally, unless we're talking about a malpractice case, you're not going to be interested in those because they're just going to really talk about who entered what when. I don't see those in many cases except for malpractice cases where there might be a missed medication or something of that type. So HIPAA, okay, is a rule of inclusion. And I think that's the primary issue that we get to here, is that it is in fact a rule of inclusion. Everything is covered by HIPAA. And if it isn't covered by HIPAA, it's covered by the Iowa Identity Theft Act, it's covered by the Social Security regulations, it's covered by the Department of Justice regulations relating to immigration nationalization, it's covered by the red flag rules, the alternate FCC rules, the FTC rules. Okay, there is a huge amount of regulation which relates to the issues of data security and how information is passed from one point to another. So just if we get out of HIPAA, that doesn't mean you won't get pushback on something else, like the FCC regs. A lot of them are structured on the same framework as HIPAA. HIPAA is kind of the great granddaddy, and a lot of them are structured on the same way. So all of them are rules of inclusion, basically, and you have to prove that it doesn't apply. You have to prove to the person who is the custodian of the data that these rules don't apply. So some of the common exceptions include things like the public policy exception. That's actually fairly broad, okay, when we talk about this stuff. Public policy exception is things like Iowa Code 141A, which is Iowa's HIV/AIDS statute. Under 141A, if you're a patient and you come in for testing, okay, I, as the provider, and you test positive, as the provider, I am required by law to report the positive test to public health. There is also a secondary thing where I may, as the provider, choose to provide partner notification, to let your partner know that you've tested positive for HIV/AIDS. None of that is precluded by HIPAA. Okay, all of that comes under the public policy exception to the HIPAA privacy regulations. If you have Ebola, okay, so there's actually something called the Ebola exception. I'm allowed to tell public health you have Ebola, so nobody dies. I mean, it's really basically nobody dies because of HIPAA. Another common exception here in Iowa, with which if you do criminal or assault cases you might see, is the wounds of violence exception. So if I come in to be treated for a gunshot wound, a stab wound, or any kind of injury to multiple organ systems which could result in organ failure or death, that all has to be reported to the police department. That comes under wounds of violence. And so you might see or feel like there's a HIPAA violation because of that reporting, but that's actually required under law. Another public policy exception is an OSHA exception. If one of the workers at a hospital, if a field worker like an EMS personnel gets a sharps injury, so a stick, and there's a bloodborne pathogen, then that person can require a HIPAA test, or the hospital or the provider can require a test for HIV/AIDS on the patient. So you're getting triage in the field, the EMS worker gets a stab or a splash, the hospital can test your blood for HIV/AIDS without your consent and without telling you, and then tell the employee so they can start prophylaxis. So that's not going to be a HIPAA violation, that's going to be an exception. There is a limited exception for law enforcement. The place I get the most questions about this from lawyers is typically on OWIs and something of that type, but there are limited law enforcement exceptions. So if you are a law enforcement officer, you can come into a hospital emergency room and you can say, we found a car crashed into a tree and there's a ton of blood on the windshield. It looks like somebody took a header in an accident. Do you have anybody who came in the last hour with injuries consistent with that? Okay. My EMS personnel can then say, yes, Bob Smith came in. Here's his address. We released him. Here's his address. Here's his social security number. He had injuries consistent with that. If they come in and they say, we had a meth lab burned down, did you have anybody come in with significant burns? They can tell them that. They can tell you tattoos, social security numbers. They can tell you what kind of injuries you had, whether they've released you or not. They cannot, however, under this limited law enforcement exception, they cannot provide information regarding blood tests, genetics, ultimate treatment outcomes, any of those kinds of things, but they can provide that more generalized information. So that's the limited law enforcement exception when there is a potential investigation. Now, under Iowa law, we can go even a little farther depending on how the people came to be in the hospital or how they came to be getting treatment. So Iowa, of course, has the Ed Thomas law, which is Iowa Code 229.22, and that's named after Mr. Thomas, who was a wrestling coach in Parkersburg and was murdered by one of his ex-wrestling students. In the Ed Thomas law, basically what it says is if the police bring someone into the hospital for treatment and that person is already arrested or there is pending charges, so they've been charged or there's an arrest warrant or they're already arrested, the police can say, we are bringing him into or him or her into the hospital, and you have to notify us before that person is allowed to leave. So you have to notify us. The intent there is almost a Tarasoff standard to get in front of potential harm and damage for people who might not be psychologically stable. Now, you cannot use that, okay? They cannot use the Ed Thomas law unless the person is been brought in by the police or they've been arrested and, okay, not just or and, they've been arrested, there's an arrest warrant, or there are charges. Okay, so they can't use it for every drunk they bring in, every person that behaves inappropriately. We get a lot of sheriffs who bring people into our hospitals and just kind of dump them off because they're worried about them, but they don't want to arrest them, they don't want to charge them, they don't want to do any of that, because if they do that, the sheriff's department can be liable for the cost of treating those people. So there's a real balance with that issue. Another issue that crops up with this sort of limited law enforcement thing is do we let the law enforcement into the room? And if you do OWI cases, you do domestic assault cases, any of those kinds of things, a lot of time you as the attorney don't want the police officer in the treatment room. You don't want them back there talking to your person when they got a morphine drip and they're dealing with this or dealing with that, those other kinds of things. The police can ask to go back unless there is a positive danger or that person is actually under arrest. So if the person is under arrest at the time they bring them in, they have a right to accompany them for treatment. If they are not under arrest, though, if this is one of those circumstances where they just want to come question the person, the hospital will ask the patient if they mind if the police officer comes back. But the police officer, again, doesn't have an absolute right to go in there. So that's going to be something of attention that you're going to want to talk to clients about, talk to people about who do you let into the room, okay? The other thing that comes in with limited law enforcement issues is that hospitals face a lot of people who could be dangerous. Most of them have policies on contraband, so if your client is in an accident and we go to strip him down because he's in the EMS, he's getting emergency medical services, we need to deal with that, and like a gun falls out of his pocket, we're normally going to ask whoever's with him to take that gun outside, and we're not going to call the police. A machete falls out, we're not going to call the police. A grenade, we're probably going to call the police. Any kind of explosives, we're going to call the police. Normally, if cocaine or drugs or something falls out of the pocket, they might put it in the biohazard and destroy it. Okay, they're not going to keep it, they're not going to maintain it, they're not going to hand it off to somebody else, which makes them collusion. Okay, they're not going to traffic in drugs, but they'll probably biohazard destroy it. But the law says they can call the police. Okay, so if your client, who is also a patient, is committing an illegal act on the premises, the hospital can call the police, the doctor can call the police, the dentist can call the police and can tell them about those illegal acts. Okay, so they can do all of that if they need to. I will tell you, I normally recommend, particularly when we have drug issues, that we don't automatically call the police because I think it sometimes can interfere with care. So we had one the other day where a guy was shooting up in the bathroom, and the nurse called the police. My preference in that would have been for the nurse to call the doctor and for us to have a conversation with the patient and the doctor about the drug abuse, about the substance issues, about getting that person into treatment, rather than simply calling the police, because the intent of the hospital is not to act as law enforcement, but to provide treatment. But alternatively, a couple of weeks ago, I had a guy come in and rip the morphine drip out of his girlfriend's arm because he wanted the morphine, and he took the bag with him. We called the police. Okay, because that impeded patient care, that placed another person at risk and danger. So they do have the right to do that, to call the police. The Ed Thomas rule is pretty limited. Okay, there's some real exceptions there. One of the other things that we get with police officers a lot of times, and we get when you all are looking at different kinds of cases, is requests for all the security data. All the surveillance footage, those kinds of things, that's going to depend on where that surveillance footage comes from. Okay, so if the surveillance footage is of the parking lot, right, so that's a public, moderately public parking lot, hospital parking lot, people come and go, maybe we park in there to go to the Dairy Queen. Normally, we are going to just hand that parking lot footage over to the county attorney, to the police, to someone else for part of their investigation, because it's going to fall under this limited law enforcement exemption and might, in some circumstances, not even be HIPAA, particularly if, like, say, everybody's parking to go to the local parade for a football game or something. It might not even be HIPAA. So we're going to turn that over. If anybody wants internal security footage, though, that becomes much more complicated, because you're not normally going to have just one person. You're going to have other patients, other family members, other people, and that becomes a process of de-identification. And as we talked about, de-identification can be very complex. So that is a significantly more difficult thing to provide. It's not a standard record, and it's not going to fall under the cost limitations. So like 62210 has cost limitations on what a hospital can charge you to produce medical records. These security footages, de-identifying the security footages, won't fall under those cost limitations. And so that could be an expensive proposition that you're going to want to think about before you ask for that in any kind of discovery. Another thing that we typically have when we look at this is workers' compensation. Workers' compensation records are not part of HIPAA. Okay, Chapter 85 is completely excluded from HIPAA, so that's not going to be HIPAA. That comes under those rules. It's not going to be a HIPAA issue. But 62210 isn't a HIPAA exemption. Okay, so 622.10 is the statute that we normally use when we have some kind of personal injury case or something of that type. You have your condition at issue and risk, and so we would use 622.10 to require the production of certain kinds of medical records. 622.10 requires that you in fact have a legally cognizable release. Okay, so you have to have a legally authorized, legally valid release as part of 622.10. Gives you some ways to get it, okay, although there's some time constraints with that, like you have to give the opposing counsel 60 days notice. The hospital gets 30 days notice to produce records pursuant to it. But there is a process. 622.10 isn't a HIPAA exclusion, okay? It doesn't fall under that sort of automatic exemptions, which means it's a process you would have to follow, and if you want something from a covered entity, you're going to have to tell them that you've met the requirements, that you've met the process. So, Christy, do we have any question, chat? Okay, so people are basically stunned into submission by the complexity of HIPAA. I like that. It means I don't have to do very much. So let's talk a little bit about getting the records. Now there's way more slides here, okay? But the slides that are most important are probably slides 4 through 11 because they're about the core of it. The rest of it is for those of you who wanted to know more about the functionality of HIPAA and what it does. That's probably going to be valuable to you only if you have a case involving an institution or something of that type. So let's talk a little bit about actually getting the records, okay? The first question you want to ask yourself is whose records are these? Who do these records belong to? Because there is a lot of stuff that is either gathered or created by a hospital that doesn't belong to the hospital, okay? So you need to make a distinction between who owns the records and who doesn't. And the first distinction there is what's a forensic document and what's a treatment document. So hospitals are asked to collect a lot of forensic documents. That might be like a blood test under 321J for an operating while intoxicated. It could be a rape kit. It could be a victim services statement. It could be all sorts of things that they collect. And those records don't belong to the hospital, right? So the hospital's going to tell you get them from somebody else, from DHS, from the police department, from that kind of thing, because they don't really own them in a way that allows them to produce them. I'm not saying you can't get an order to do that, but what you're going to get is pushback on the initial subpoena. So if you're short in time, you're going to get a lot of pushback on initial subpoena for anything the hospital doesn't feel is theirs, okay? Isn't an internal treatment record, isn't an employee record, isn't something that's theirs to share. That is going to be particularly true in DHS cases. So if you have a mandatory reporting on child abuse, if you have mandatory reporting on dependent adult abuse, any of those kinds of things, the hospital is going to treat those records as if they do not exist for the purposes of production because of the rules that relate to child abuse, dependent adult abuse, those kinds of things. That's going to be a pretty absolute block for you. So you want to look to who owns the records. Who can actually provide those records to you under law? So that's the first place to go, is take the forensic items away from the treatment items and then determine who owns what records. If you are sending a subpoena all by itself is almost always going to raise a red flag, okay? Because the first thing a hospital is going to be worried about is, are you suing the hospital? That's the first thing they think about every time they get a subpoena. Did somebody here do something wrong? It's how they're trained. It's how HIMSS works, Health Information Management. So they're going to be worried about that. If you send a letter, okay, that encompasses a couple of basic things with the subpoena, in all likelihood you will get better cooperation in terms of providing the records. I probably get 3 or 4 calls a day from some type of provider, long-term care, hospital, clinic, or lab, asking me if they have to produce records or what records they have to produce pursuant to a subpoena. So if you have a letter that tells them some of the basics, that will help them make that assessment more quickly, particularly if you need records to move forward. So a letter it doesn't have to be detailed, but this is a case involving a car accident. You treated this patient at X, Y, and Z time. We are requesting the records for this purpose. And very importantly, we have talked to opposing counsel, and opposing counsel has no objection, okay? Because one of the things that happens to hospitals is those records, let's say you're representing the insurance company, those records don't belong to you. They belong to the hospital and the patient. And if you haven't sent a patient consent, the hospital has to figure out, Does the patient know? Is the patient asserting a right? Do we have an issue here? So if you say directly to the hospital, okay, that I've asked the other side and the other side is not objecting, that will expedite requests. That will make it easier for them, and they don't have to hunt. Okay, they don't have to look on the subpoena to see who you copied. They don't know all the lawyers. They don't know everybody. They don't know any of that stuff. So make it easy for them to know what you want, why you want it, and that everybody who has a dog in this hunt has already dealt with it, okay, so that we don't have a motion to quash. The flip side of that is if you don't want those records produced and you think you're going to be filing a motion to quash, don't count on your client to convey that to the physician, the hospital, the provider, because frankly, they don't do a very good job. In general, they kind of mess up the facts. I mean, some of them are very sophisticated, very good at communicating, and some of them just go in and say, you can't produce the records. Well, if I've got a valid subpoena, that makes it very complicated for my hospital to make some kind of determination about producing the records or not. So if you're going to file a motion to quash, either you or your assistant or your paralegal just needs to call up HIMSS, okay, call up the health information manager, call up medical records and say, we understand you got a subpoena, we are filing a motion to quash, please don't produce anything until that's been addressed. And then they won't produce it, because you never know if they're going to wait 30 days or 10 days, or they've been looking at the record for something else and it's going to go out that afternoon, right? So get ahead of that issue and don't make the hospital guess about those kinds of issues. So if you're going to move to quash, let them know. All right, let them know right away. And I know time gets away from all of us. I know it's complicated for all of us, but you want to let them know right away. And then this is probably the best piece of advice I can give everybody. This is the most important thing I'm going to say to you. And if you learn nothing else today, learn this. Don't be a jerk. All right, don't be a jerk when you ask for the records. Guess what? They're not scared of you, right? You are not the scariest person on the block. I understand. I've had many people say to my hospitals and then say to me, well, I'm going to haul you in contempt of court. I don't care. Okay, I can go in and I can explain why you didn't meet the technical requirements, why you didn't do what you were supposed to do. You are not the scariest person on the block. The scariest person on the block is CMS, the Center for Medicare and Medicaid Services. Because if we don't do stuff right, they can stop paying us, right? They can prevent us from admitting new patients, whether it's long-term care or a hospital. They can take away all of our money. They can shut our doors. That is a lot more scary than you having to talk to me and have me explain why we can't produce something. The other thing you can do is you can say, can I talk to somebody else? Can I talk to your counsel? Can I talk to somebody else? Can I talk to the privacy officer? If you're not getting what you need from HIMSS, it's always perfectly appropriate to talk to somebody else. But if you're polite, again, they will move a little more quickly to expedite the records and the things that you're requesting. I get an awful lot of calls from my directors that say, this person's been a jerk to me. Okay, they've been a jerk. And then when I call the attorney, everybody's perfectly nice. Okay, everybody's reasonable, they're fine, we work through whatever issue it is that we need to work through to produce the documents. Remember, the hospital doesn't have a dog in this hunt, okay? They don't care. Unless you're suing the hospital, they don't care about the records. They want to get them to you, they want to help, they want to cooperate, but they don't want a problem. Okay, they don't want CMS to find them. They don't want an OCR desk audit. They don't want those kinds of things. So they're going to jump through the hoops, even if you think the hoops are stupid. Okay, they're going to jump through those hoops. So just be polite. The next thing is that, in all honesty, a subpoena alone isn't sufficient for a lot of the records you really want. A subpoena can get you the record of my broken arm. Okay, so just a subpoena standing alone, preferably with a letter and some little politeness, can get you my orthopedic record for my broken arm or my elbow surgery. It could get you the record for you know, a broken ankle, or that I had migraine headaches. It can get you that kind of stuff. There's a whole bunch of stuff it will not get, okay, that you cannot get. And you are either going to need a legally sufficient consent, okay, or you're going to need a specific court order. And when I say a specific court order, I don't mean an order that says any and all medical records, because that's not sufficient under the statute. If you want mental health records and you do not have a legally sufficient consent, the court order has to say mental health records, okay? It has to be specific under the law. So there are several laws and several types of information that you cannot get with a subpoena alone, which will either require consent or court order. The first of those, and the one you probably run into most frequently, is mental health records. Okay, so those are covered primarily by Iowa Code 228 and 229. And mental health records require patient consent. If the patient is not competent, it is going to require consent from like a durable healthcare power of attorney or someone similar. A simple power of attorney normally isn't going to get you where you need to go with those kinds of records because of the nature of 228 and 229. You are not going to get psychotherapy notes by subpoena. You probably won't get psychotherapy notes with a patient consent or with a court order either. Psychotherapy notes are a very limited category of records recognized under HIPAA and state law, which are really the personal notes kept by a mental health provider. They're not part of the electronic medical record or the EMR. They're not shared with other physicians. They're not used for continuity of care. They're individual and personal to the treater, the provider themselves, him or herself, and they're not shared. That's a psychotherapy note, and you're probably not, you're not going to get that. Those are exempted from the law. The other thing that you're not going to get, regardless of court order, is typically peer review. There's a separate statute for peer review, and that's subject to a very extreme privilege, so you're not going to get that. The Iowa Board of Medicine doesn't even get a lot of the peer review kinds of documentation. Psychotherapy notes, peer review, the more generalized things, and then of course raw test data. So like something from an MMPI, that kind of thing can only be released to another psychotherapist. They can only be released to a psychologist. They can't give you as an attorney, unless you're also a practicing psychologist, the raw test data. So there's going to be some limitations there, even with a consent or with a court order. And again, a court order that says any and all isn't going to be sufficient for those kinds of records. Another specific state statute that limits the production of records is Iowa Code 141A. That's the HIV/AIDS statute, and you're going to have a consent or, again, a specific court order that says HIV/AIDS records. Now, you can address both of those things by using the bar form consent. Okay, so the Iowa State Bar Association, with the assistance of the health law group, has a legally sufficient consent form. You can get that form, but remember there are check boxes on that. And if they don't check the box or initial the box that says HIV/AIDS records, mental health records, that kind of thing, it will not be sufficient for those records. So you can't just have a blank, a generalized one or a blank signature. You're going to have that. And trust me, the facilities are going to look through every piece of that. They are going to make sure that it is a legally sufficient consent. You are also going to have facilities that want their own consent, and sometimes that's just going to have to do with the facility. Sometimes that's going to have to do with the nature and quality of the stuff that they do. Another one that's going to be problematic is if you want substance abuse treatment information from someone who's participated in a substance abuse treatment program. Not gone to the EMS because they had an overdose, not, gone to their doctor and said they had an issue with depression, that kind of stuff, but actual substance abuse treatment through like a federally funded clinic. That's governed by 42 CFR Part 2. The people who work with that is SAMHSA, which is the Substance Abuse and Mental Health Services Administration. SAMHSA has proposed some changes to the regulations that relate to how you would produce documents under 42 CFR Part 2. Those are actually going to make that rule more complicated. So they've gone back to relook at those because they're going to be more complicated. The thing to remember about Part 2 is if you have a client who has been involved in this kind of Part 2 treatment, a generalized release will not be sufficient. It is a specific release. So it is the Acme treatment facility to Bob Jones' law office. It can't be any treating provider to Bob Jones' law office. It has to be specific to the facility itself. So if you have a patient, maybe we're trying to do sentencing, whatever you're doing, and they've been in and out, they've had a couple of those, you're going to need more than one consent because under the Part 2 rules, they're going to have that consent has to be specific to the provider. Okay, it's not any and all, it's specific to the provider for those. Now that's a relatively small grouping of treatment facilities and providers, but you're going to have that issue. You're going to have that there. You may hear about GINA being a specialty category, which is the genetic information under the Genetic Information and Non-Discrimination Act. Part 4 of the HIPAA high-tech rules actually deals with GINA, but GINA is not an issue for the provider. Okay, GINA is really only an issue for employers and people of that type. It looks like we have a question. Hang on. Yeah. Okay, so I have two questions. I'm going to try to answer both of them. The first says, recently hospitals and other providers have been sending their own authorizations to get medical records and rejecting the Iowa bar form. What is going on here, and is there a problem with the form? So in Iowa, there is not actually a problem with the form. For the purposes of Iowa law, the form meets all requirements of Iowa law, which is our specialty rules, 228, 229, 141A. It also encompasses the 42 CFR Part 2 requirements. A lot of the issues that you're experiencing have to do with facilities or groups that are also treating people in other states, okay? So one of the places we get a lot of pushback is the Hy-Vee pharmacy. Okay, we get a ton of pushback from the Hy-Vee pharmacy when our people are trying to get records, and it's because they do a lot of work in Wisconsin, and Wisconsin has an entirely separate law that relates to developmental disabilities. And you have to have language in a consent about developmental disability information if that consent is to be valid. So that's part of the reason you're probably getting this. Some of it is that you just have some really big organizations, and the University of Iowa is very common for wanting their own form. The University of Iowa wants its own form because it wants them all to look the same. And it is easier for them to say, send us our form, than it is for them to take potential variations on the bar form or to take forms other people have created. And if the organization is big enough, right, they're the 800-pound gorilla, and if you need the records enough, you're going to complete that form. So really, it comes down to two different things. The section form is fine, okay? I mean, it really is. We've been through it a couple, 3 times. The section form is fine. If you want to encompass the states that surround us, we probably need to add something to that form about the Developmental Disabilities Act in Wisconsin. And then the other issue is just that some places want their own form. The other question, how does one determine who owns or gives permission away to information? It is always the patient in med info. I think the question there is who owns the documents, right? Okay, and I want to talk a little bit about that as we talk about minors as well. So let's talk about who owns the documents. The easiest way to start thinking about that is first is that forensic versus treatment issue, okay? Because when there is a forensic document, the hospital or the provider almost never owns the documents, okay? So if someone is sent to DHS, someone is at DHS, maybe it's a child in need of assistance, there is a court-ordered evaluation of the children, those documents are really the courts or DHS's to release as opposed to the providers to release, because that's who ordered it, that's the consenter for the treatment. If there is the collection of forensic data, so you have a request for a blood test. So guy's in a car accident, they think it's drunk, the police have arrested him, they think it's drunk driving, he's not conscious. They can draw blood under 321J, but that blood draw is at the request of the police, and so it's forensic. All right, so that's probably where you're going to have to get that. I'm not saying you can't get it from the hospital. I'm just saying it's quicker to get it from the police or to get it from DHS. And they're going to have to, if the hospital were to release it, they have to jump through a bunch of hoops and basically get permission from DHS, from the police, that kind of thing, because it's who consented. A lot of times, who can allow the release of information follows who consented to treatment. So if you have a client who's in jail and gets treatment in the jail is basically consenting to the treatment because that person is being controlled by the jail, so you have to get the information that way. Another place that becomes really tricky is when minors consent to their own treatment. So there is no set age in Iowa where you automatically can consent to things. All the statutes differ. So a minor can, and there's no set age again, a minor can consent to STI or STD treatment, so testing and treatment, sexually transmitted infection, and can consent to that treatment without telling your parents. But what that means is if you need to access that data, the person who consents to that access is not the parent. The person who consents to that access is the minor. It's who consented to the treatment. That is not true in divorce cases because each parent equally shares custodial, unless there's a separate order, custodial obligations for the child. So a non-physical custodian can consent to treatment but can also receive records that were consented to by the other person. But in general, when we are looking at this, it's who consents to the treatment. So you have the forensic issue and then the who consents issue. That can be very difficult if you are working on cases with minors because minors can consent to a variety of things. If they're 17, they can consent to blood draws, and they can consent to blood donation. Younger people can consent to, like I said, STI testing. A minor can consent to inpatient mental health testing. There's no limited age for that, but not outpatient counseling. So there's a lot of rules there, and you might ask what other documents are there, what other issues there are, but start with the forensic issue and then look at the minor issue and look at who else is treated. The other thing you're going to find with mental health records is you're going to get more pushback on that, particularly if it's kids, on the best interests of the client. So a lot of times when I am getting questions about mental health documentation, it is when there is a custody issue, a child in need of assistance, sexual or mental abuse, one of those kinds of things, and parents want access to data that the counselors feel would damage the child. You're going to get a lot of pushback. In fact, you'll probably see a motion to quash if you push on those, because the counselors are going to say that that will damage the therapeutic relationship. That is recognized by HIPAA. There is a HIPAA exception that says, you know, they defer to the states for the release of records relating to children, but they recognize that the best interest of the child trumps. So that is actually in HIPAA. That is in our statute. So that's a place that you might get pushback on mental health information if they're concerned about the therapeutic relationship and how the child will function. So you want to think about right to consent. You want to think about who would have consented to that treatment and then who could consent now. That can shift. If you have someone who is not competent and you have a durable medical power of attorney, once that person, let's say, becomes conscious, they might be the person who now consents. One of the biggest issues that we have, particularly in long-term care, is people die and have no executor. And then we have to figure out who can consent to the release of records. Is the audit, okay, so I have another question. Is the audit trail, log, and metadata that make up the EMR considered PHI, and is it discoverable as asked for with the Iowa bar form or the facilities form? So the audit trail, log, and metadata are all discoverable, okay? They are actually less of a HIPAA issue and more of a process issue. The log could be HIPAA because you're going to talk about who got what, when, and as part of the log I have to give a description of what's been produced, so that's probably still going to be HIPAA covered, but you're going to have to issue a subpoena for those things specifically, and then you're going to have to maybe talk to them about how it's going to be produced. That's going to be part of your EMR, and you're going to have to figure out how you're going to do that. One of the other things you want to think about, particularly if you're looking at a lot of EMR records, is that what a physician or a provider sees isn't necessarily in the same format that you will get. So if I'm a doc and my EMR screen comes up and I am looking at it, I have the same data you're going to get when I produce records to you, but not in the same format. Okay, so the formatting shifts between the screen I see and the data that's produced because of how EMRs are structured. And so if you have a complex case that turns on who knew what when, you might actually have to go in and schedule a time to look at the EMR itself. The thing you're going to have to remember is if you're going to do that, they'll have to have somebody sitting with you because there isn't a way for them to allow that limited access, so they'll have to be with you to prevent unfettered access. But the screen I see isn't the same formatting that you're going to see when you get that. You're going to get all the same documentation, all the same data. Lots of times the metadata isn't going to have anything useful unless you're concerned about somebody missing, skipping meds, not getting something done, or maybe it's how long somebody laid on the floor after a fall. Then you might see the metadata might have some more use to it. You still have a lot of providers, though, that are really, the chart by exception, which means they only chart when there's a problem, and that's going to be a lot of smaller providers, not hospitals. They don't chart by exception, but you might have charting by exception. And you're also going to have a lot of people who still have a real strong mix of paper and electronic records, and so that's going to create some real issues. That's particularly true of rural Iowa or smaller facilities. You're going to have a lot of paper charting still, and so there might not be any metadata, audit logs, anything like that because they're still doing so much paper charting. So you're going to have some of that. Let me see, 321J, that's really all about the OWI testing. That only comes into play when a patient is not cognizant. Okay, so when the patient is basically unconscious or something of that type, patient can always refuse a breath analyzer, blood test, any of that kind of stuff. And what I tell people all the time is that a patient can refuse a test. Okay, that's also true of drug testing from employment practices. 730.5 allows, if you have very specific policies, that you as an employer can do certain kinds of drug testing or alcohol testing, but you got to be specific. Okay, I mean that is a strict sort of statute. But the employee can still refuse. I mean, an employee can refuse to be tested. and the lab will have to make basically some kind of log of that. But I always tell my labs, don't test people who don't want to be tested. Even if somebody has asked for it, I'm not going to hold people down to draw blood. That's not what we're going to do unless it's necessary for treatment purposes. So if somebody's had a psychotic break and the doc needs to know what's in their blood because they have to treat them with something else, lab might do that. But lab is not going to do that for an injury or an illness or, you know, some other kind of thing. So patients can always refuse. Patients can also refuse to allow you as their attorney to access certain portions of their record. One of the things that happens in HIPAA is if a patient wants a certain kind of treatment and is going to pay for that out of pocket, they can say they don't want anybody to know about it. They can say you can't provide that information to insurance, you have to segregate that information, that kind of thing. If there's segregated information and you ask for an EMR listing of the patient's records, that may or may not show up. So if your client has said to you, I got treatment, let's say for gonorrhea, okay, something they'd be embarrassed about, which is why they didn't want the insurance company to know, I got treatment for this, and you want to have that because it might have affected something else or some other kind of thing, or another really common place we see it is mental health treatment. What you want to do is make sure that you say, including any records relating to, you know, patient paid or any records that are paid exclusively by the patient, which were not submitted to insurance. If you've got a patient who's asked for a lot of those treatments that are not insurance submitted. So, oh, Christy, you got another question, Christy?
I do.
Good.
I read this one up.
Okay.
Recently, we've seen service providers or parents in China cases refuse to either testify or write reports concerning the parent's treatment for either mental health or substance abuse.
Okay.
Typically, HIPAA is cited as why we're generally appeal to confidentiality.
Okay.
Is there any basis for that under HIPAA that makes we're asking for a report and not psychology?
Okay, so I might ask you to clarify that question because I can read that question in two different ways, okay? One way is we are providing care for the child. Analysis, supported community living, whatever it is we're doing, we're providing treatment for the child and they're refusing to write a report, okay? Normally, that kind of treatment, particularly in China, is going to be required by the court. It's going to be a court report and they're going to need to do that. There might be some limitations to that in terms of therapeutic relationship. If what you're asking about is, I want this social worker or this BHIS worker or whoever it is, I want them to write a report about the parent, okay, that issue has a lot to do with how are they engaged to do services, okay? So are they engaged to provide services for the parent or are they only engaged to provide services for the child? And do they learn things in their role about the parent that impact on the child? So HIPAA does have some play there in the sense that if I become aware of medically related information because I'm there as a provider, even if it's not the patient, I can't reveal it. So there is some HIPAA issue attached to that. In a lot of instances, there's a lack of clarity in the orders that are provided to these community providers, the people who do that, and it's harder for them to determine what they're supposed to be providing. I would think, though, in a lot of instances, that would be something they should or could do, but that you just might need clarification up front from the court or from both sides about what they're going to be doing. But HIPAA applies to almost everything they see when they're doing those kinds of services, but they have to separate those things out. Any other questions, Christy?
No.
Okay, so we are at the end of our time. We talked very briefly and very rapidly about some of the production issues that people will see. As I said at the beginning, I'm always good for an email answer, so if something crops up that you meant to ask or something weird happens, you're welcome to send me an email and I'll be happy to assist. But thanks for spending lunch with us today.